Thank you so much for coming out for take two. Robert Spoo's lecture, James Joyce versus Samuel Roth. Very excited for those of you who made it here from campus and from New York's Bibliography Week. I'm Carla Nielsen. I'm the curator of literature here in the Red Book and Manuscript Library at Columbia, and with my colleague Jane Siegel curated this exhibition, Publishers Provocateur Samuel Roth in Context. It's been really interesting to spend a year with Roth and to learn from people who spent a lot of time with Sam Roth's materials before then. We're very grateful to Samuel Roth's grandchildren, including Candy Kugel, who's here with us tonight, for donating the papers to Columbia, and then also to the work of scholars who really helped us interpret the materials, including Bob Spoo and also Jay Gertzman, whose biography of Roth came out this year and who is here tonight, and also Lauren Glass and J.C. Cloutier, who is the grad student who processed the collection. So all of their work was very, very helpful. I also want to thank Kenny Cruz, who's going to introduce Bob Spoo tonight, who is Columbia's copyright officer for 2 more weeks. He and his assistant Michelle Cho helped us make sense of all of the legal materials in the papers, and that was really invaluable. So I'm going to let Kenny introduce Bob, and welcome all. Thank you so much for coming.
Thank you, Carla. Thanks to everybody, to the family, to our colleagues, to everybody here in the libraries. I will keep my comments very short because I know we're eager to hear from Professor Spoo, who comes to us as the Distinguished Professor of Law and Associate Dean for Faculty Development at the University of Tulsa College of Law. Now, he also comes to us with a rich background that's absolutely perfect for addressing many of the issues in his book and I'm sure in the presentation tonight. His background is one of law as a scholar, as a teacher. It's one of law as a practitioner and as a clerk for many of the leading, for Justice Sotomayor of the Supreme Court. He also comes to us with a PhD in English literature and a career as a teacher and scholar in that field as well. And so it's exciting when you can meet somebody and learn from somebody who can bring together these different perspectives. And then certainly Roth pulls that out of you. And if ever anybody says to me, how can you deal with that copyright stuff all day long? All I have to say is, we're talking about prison terms, we're talking about obscenity, we're talking about lawyers and money, we're talking about international relations, we're talking about the public domain, we're talking about the growth of knowledge. What could be more interesting than that? And so I'm delighted. I have been delighted to read his book. I encourage you to do the same. And it is a real privilege to introduce a colleague, a friend, a distinguished scholar, Professor Robert Spoo. Please. Thank you.
Thank you so much. Thank you. That's very kind. That's a very kind introduction, Kenny and Carla. I keep thinking that this is sort of the perfect context, the perfect group, and the perfect introducers for the very mixed and complex person that Roth was. I mean, after all, the 2 introducers, one is a curator of books and a scholar of the materiality of book, a large dimension of Roth's life. Kenny is a copyright expert, a noted copyright expert, fair use expert, and all of these elements percolate, at least for me, for a figure like Roth, and I think helped me to be attracted to Roth and to start delving into him and his life and to learn about him. I do have to thank Columbia Libraries, the Friends Group, and the Kernahan Center for making this possible. I am so sorry if for any of you who came to see me 2 nights ago in that snowstorm. Thank you for that if you did. I was hiding out with my fingers crossed in a cafe next to the law school, and then we heard the announcement the school was closed. So thank you so much if you did, and thank you then for coming to this translated feast. And it is a kind of feast, not so much my talk I'm thinking of, but the exhibition, which I think is wonderful. Please take an opportunity to take that in after the talk or come back up at some point and look at it. It's truly remarkable, and I congratulate Carla and the other archivists who put that wonderful exhibition together. It's got bite-sized pieces of Roth's life as you walk from case to case, and a very logical and very clear presentation, I think, of a lot of dimensions of Samuel Roth. Well, we have Bibliography Week here. We have, I think, some folks from that event. We have Joyceans here. We have some Rothians. We actually have a Roth here, or a Google here. It's perfect. It's perfect to capture, I think, a little bit of the complexity of Samuel Roth and his collisions with law, literature, publishing, really with history itself. He's a man who has collided with history, and history has not been terribly kind in that collision. And I hope that the talk today will give a little bit more richness to the idea of Samuel Roth, because the idea of Samuel Roth that has been largely current for 80 or so years, I think, is in need of some complexifying. Someone close to him recently described him as flamboyant, sentimental, unjustly dismissive of all kinds of people, fiercely loyal to his friends, chronically unserious, and often astoundingly irresponsible about what he said or did. That's one snapshot. Samuel Roth's daughter Adelaide called him, it's a remark that you can find in the archives here, a man of loves and hates, not of likes and dislikes. He was passionate. Now, with the availability of the Samuel Roth papers here at Columbia, of which this is a beautiful picture that we have at the exhibition, with those papers, the passionate complexities and contradictions of Roth are more recoverable than ever before. And it's really happening. And I think of the year 2013 as the year of Roth in many ways. Aside from my book, Jay Gertzman's wonderful biography of Roth, Infamous Modernist, came out and is helping us to understand who Roth was. The first full biography of Roth. There had always been shorter pieces. This is a full biography, and the man is much more than his previous snapshots. Also, a book called Obscenity Rules, Roth versus United States, and the Long Struggle Over Sexual Expression came out from Kansas. This is a book by Whitney Strub, who's an historian. So we have in 1 year on Roth a book by an historian, a book by a literary scholar and scholar of erotica and so forth, Jay, and a book on Roth by a lawyer / literary scholar. So a lot of different types of people are attracted to Roth. Today I'm going to tell you a story about a lawsuit filed more than 80 years ago in this city by James Joyce against Samuel Roth. Many of you may be familiar, of course, with the international protest that Joyce's supporters at his instigation launched in 1927. Less familiar to you may be part 2 of that strategy. Part 2 was the lawsuit that he filed against him here in this city. But I'd like to just begin with a very short list of nots, N-O-Ts, about Roth. He was not simply the callous purveyor of a quaintly libidinous modernism. Rather, he was an antinomian, rule-flouting poet, author, and publisher with a deeply felt aesthetic commitment to the authors he admired and printed and reprinted. He was not being a hypocrite when he protested his love, and that's his word, for James Joyce and his writings. And he was not a copyright infringer. For the law students and lawyers in the room, that will have a special meaning. He was not a copyright infringer when he reprinted Joyce and many other authors without permission, often, though not always, without remuneration. In fact, you have to look very, very hard to find Roth involved in any copyright litigation at all. I think I found one suit with Jay's help in the 1950s, but a very minor matter, and of course clearly after the period where he is notoriously associated with piracy. Roth was a devout breaker of obscenity laws, not copyright laws. And it was the U.S. copyright law and its product, what I call the American public domain, that made Roth and his lawful piracies possible. Roth was an embodiment, I think, of the American copyright law of the period. The statute rather luridly and colorfully personified. The statute made him. The law made Roth in many ways, or at least made him possible. For much of 2 centuries, the American public domain was a vast, brimming literary commons assembled in great part from the legal have-nots of foreign authorship and reflecting the policies of a developing nation in quest of instant and assured culture. It was nothing less than an aggressively legislated commons, an invitation to state-authorized piracy that served the interests of the printing trade, book manufacturers, and an increasingly literate populace. From the first federal copyright law of 1790 and well into the 20th century, the American public domain grew daily through the influx of new, freely available foreign works. And by operation of the copyright law, specifically the notorious manufacturing clause, which required typesetting, and later both printing and binding on American soil as a condition of copyright protection in the United States. As a result of that manufacturing clause, many foreign works were claimed almost as soon as they were issued abroad by a preternaturally premature commons. The story of lawful piracy's role in building an American literary culture and reading habits has not yet been fully explored. You often hear an elliptical and abbreviated version of why works of erotica and so forth were in the public domain. They said that an obscene work could not have a copyright in the United States. That's actually collapsing things. The real reason why is that many of those works simply did not satisfy the manufacturing clause. They were previously published abroad, and therefore they lay in the American public domain. It was not immediately, and certainly not the case with Ulysses, that obscenity status meant no copyright. There's an in-between there which has to do everything with the copyright law. The absence of copyright protection for foreign authors inevitably created a feeding frenzy for valuable free resources among American publishers, or reprinters as they call them. But free resources don't remain valuable if the feeding frenzy depletes them. So into this copyright vacuum, this legal loophole the size of a nation, stepped a countervailing practice called trade courtesy, or courtesy of the trade, an informal norms-based system evolved by American publishers to regulate ruinous competition for foreign titles, and to give themselves as publishers an aura of respectability. In other words, you have all these riches from abroad, but if everybody's going to publish them, then you have no incentive. So how do you reconstruct the incentive? Under trade courtesy, the first publisher to announce plans to publish an authorized American edition of an uncopyrighted foreign work acquired title, courtesy title to that work, a kind of makeshift copyright regime grounded on tacit trade agreements and community-based norms. A publisher's claim was respected by participating publishers who might, and often did, offer gratuitous, that is, uncompelled payments or even royalties to otherwise helpless foreign authors. The practice restored a precarious order to the publishing scene, an order that was always menaced at the edges by those who didn't participate, the new publishers, the upstarts, the deviants, those who just didn't care. They didn't owe anything to the prestige houses who participated. Authors without copyrights could, under courtesy, at least hope to look to the largesse of publishers for a voluntary and improvised justice. Enter Samuel Roth. For various reasons, courtesy by the 1920s had become an internalized corporate ethic rather than a flaunted chivalric code as it had been for the 19th century publishers who were very proud of their good manners. By the 20th century, it's still operating for various reasons I talk about. It had kind of gone underground, but it's still there, quietly operating. It was observed, again, quietly, even by the new insurgent publishing houses of B.W. Hupsch, Alfred Knopf, and the Bonai brothers. As I argue in my book, the story of Bennett Cerf's heroic publication of the first authorized American edition of Ulysses is, in large part, though it has not been talked about much, a story about courtesy, carefully deployed to repair and forestall the ravages of piracy. In a sense, that story, which is also largely documented in these libraries as well, the Cerf papers and the Random House papers, it's a story about, in a sense, opening and closure, because when Cerf went to all the trouble to hire a lawyer who took the obscenity ban off or got it taken off, now nothing lay in the way of anyone in the United States publishing Ulysses. So in a sense, the obscenity ban operated as a kind of a super copyright, preventing everybody, including the author himself, from publishing it. Once that's gone, and Cerf, you can see in these papers, Cerf's great fear that once I go to all this trouble, now this uncopyrighted work, which everybody at the time knew was not copyrighted in the States, it was just simply understood, now anybody can go after it. So what do I do? Well, the answer complexly was courtesy. He availed himself, Cerf did, of that courtesy tradition. Roth himself sometimes practiced a raffish sort of courtesy. He paid foreign authors fitfully, according to mood and circumstances. He even offered Joyce post hoc gratuities off and on, in one case an advance payment. But in the end, he returned often with almost relieved fury to buccaneering form. That was part of him. Roth had neither the real nor the cultural capital to sustain his flirtations with business morality, and this is a point that Jay Gertzman brings out, I think, very strongly in his writings on Roth. Courtesy costs some money. You have to have a certain prestige. You have to have a certain level of operation, which Roth was never able really to attain to. So he operated often by necessity without courtesy. Joyce, a writer without copyrights, but with a keen sense of the deference owed to his genius, resented more than anything, I think, Roth's studied discourtesy. In retaliation, coldly and deliberately and very effectively, Joyce wrecked Roth. Samuel Roth built his magazines of the 20s on two things: uncopyrighted works and authors' names. Both were free resources that had been gifted to the American public domain by protectionist laws and the growing marketability of modernism. Roth drew upon the nascent celebrity of avant-garde authors to boom his magazines and tout the multiple virtues of their contents: literary experiment, freedom of speech, and erotic appeal. He was not just making free with the names of controversial authors. He was also, in his mind, working, I think, with fellow intellectuals and artists to administer needful shocks to a society bound by prudery and prohibition. In the midst of the forbidden abundance that was made possible by law, copyright law, Roth reveled for a time. Copyright-free materials swelled his magazines. The bankable names of authors gave his enterprise an aura of sophistication and intellectual purpose. The first issue of Two Worlds, which is Two Worlds and Two Worlds Monthly, are probably his most famous, at least through the Joyce connection publications, appeared in September of 1925, bearing the names of three contributing editors: Arthur Simmons, Ford Madox Hoofer, by then called Ford, but he was called Hoofer on the page, and Ezra Pound. Pound now might not have objected to the use of his name if he had thought that Roth was running a legitimate operation. But by 1925, Pound had learned from Joyce that there were questions about piracies and things, and he wanted his name, and he sent a letter to Roth demanding that his name be removed as a contributing editor to Two Worlds. Roth responded with feigned puzzlement over Pound's quaint sermon in conduct, as he called it, but he agreed to remove his name from the cover and all stationery, though he hoped the poet might reconsider and come back to us. Pound did not come back, but even in defeat, Roth found a way to exact a spurned pirate's revenge. He wrote Pound's father in Philadelphia in February 1926 to inform him that he intended soon to publish some of his son's poetry in his magazine. Pound, learning of this, Ezra, erupted, cabling his father, "Issue injunction immediately, preventing Two Worlds printing anything over my name." People thought that had to do with copyright. It doesn't really have to do with copyright. These things he could print were in the public domain. It's about his name. He doesn't want his name used on the cover. He saw clearly that the real point was to keep the Pound name in circulation. Pound's name was, at that point, strongly associated with the cutting edge of avant-garde publishing. Pound did what he could, but neither the law nor self-help really promised any relief. And Pound did fantasize, as he put it, about wringing Roth's dirty neck. But even here, Roth was a step ahead of the fuming exile. Veering from servility to pugnacity, he threatened Pound with a personal lesson in correspondence that he would not soon forget. He had always been able to handle half a dozen goyim at one time, as he put it, and would have no trouble with, as he put it, one masturbated pimp. He added that he had composed an epitaph for Pound's tombstone, and he wrote it out for Pound. Here it was. "Here lies Ezra Pound, most woe-begod of men. He wet his shirt tails twice, ere once he wet his pen." He actually published that, too, and with Pound's initials in one of his magazines. He was clearly bent on retaliating for the poet's defection from the magazine. And he turned then, after this little barrage, to the American public domain for his revenge. He ran two of Pound's poems, in Immorality and Song. The choice is very Rothian. A little poem called An Immorality, which is anything but what the title actually suggests, and Song, which is a translation from Heinrich Heine. And he ran that in the August 26 issue of Two Worlds Monthly. Both pieces had appeared in Britain earlier, and they were in the American public domain. Failure to comply with the manufacturing clause. Pound's verses were now keeping company with in Roth's pages with works by Joyce, T.S. Eliot, Carl Sandburg, and others who had published abroad in some of their work, and other exiles. Or exiles and writers who had failed to obtain U.S. copyrights. Although he had lost the controversial exile as a contributing editor, Roth regained him as an involuntary author and extracted, again, publicity value, I think, from his name. T.S. Eliot was another of Roth's trophies. Roth reprinted his fragment of a prologue and Wanna Go Home Baby, a fragment of an agon, in a 1927 issues of Two Worlds Monthly. These pieces, which as many of you know, later formed parts of Eliot's unfinished poetic drama Sweeney Agonistes, had recently appeared in the Criterion in Britain and again lay reliably in the American public domain. Eager to take full advantage of Eliot's growing celebrity, Roth actually dedicated an issue of his magazine to him as a writer, quote, "who has given us some excellent verses, several sound critical formulae, and one of the most charming literary personalities of our time." Eliot was so annoyed that he wrote the New York Evening Post with an uncharacteristic complaint that Mr. Roth chooses to interpret any gift to the world as a gift to himself. Roth replied, justly, that this perverted the meaning of his dedication, which was that Eliot's poems were given to our generation. This is a kind of thinking of Roth that you find again and again, this notion of art which is a kind of a spiritual donation that is available to everybody. Once it is created, once it's made available, it should be circulated. But Eliot had construed the dedication as a pirate's credo, rather than as the philosophy of a man for whom the niceties of courtesy were less important than the dissemination of valuable public goods, or gifts, as he thought of them. A part of him really believed that authors created spiritual donations, and the donation should be kept in motion. To glance at Lewis Hyde's definition of the gift, the perpetual donation, the gift that should be kept in motion. For Roth, the legal public domain was simply a pragmatic reflection of this economy of gifting. Humiliated by Eliot's public rejection of his dedication, and he was humiliated, Roth lashed out by telling the Evening Post that he had printed one of the poems as a specimen of the sort of rubbish, he said, which is labeled out to us these days as poetry. Of course, he didn't feel that way about Eliot. And he also said that he was mailing Eliot a check for $25 as a mere formality, as he put it. Roth's gesture here harkened back to the courtesy payments that publishers had made to unprotected foreign authors during the previous century. Except that Roth was twisting the tradition to punish Eliot for excluding him from the collaborative circle of modernism. But Eliot would have no part of the game, as he called it, Roth's game. He said he stiffly forwarded the check to the Evening Post and said he would not accept bribery or hush money from the New York publisher. In this ritual of gift giving and returning, one thing remained constant: Roth's determination to boost his magazine through the uncompensated use of a famous author's name. No name, possibly with the exception of his own, appeared as consistently in these magazines as that of James Joyce. One reader of Two Worlds Monthly wrote to Roth to say, and I'm quoting the letter here from a fan, on the principle on which it has come to be known that Blue Valley butter is good butter, every intelligent reader in the United States has come to know that James Joyce is a good writer. Ostensibly lauding Roth for his promotion of literary excellence, the reader astutely pinpointed the trademark-like use that Roth was making of authors' names to brand his magazines and stimulate consumer interest. Roth drew upon the signifying power of literary celebrity as a grocer might plaster his storefront with posters for butter brands. Like butter brands, modernist authors increasingly now in the mid to late 20s began to acquire a market appeal and a market value. In 1926, late 26, Joyce decided to test the value of his name by suing Roth and his publishing company for $500,000 in damages for the commercial misappropriation of his name. But at this time, John Quinn having died several years before, Joyce had no lawyer in the United States, so he had to find one. After some difficulty, he and his Paris publisher, Sylvia Beach, found the New York law firm of Chadbourne, Stanchfield, and Levy. We now know them as Chadbourne and Park, 8 floors of 30 Rock, a very powerful firm. Now and then was getting started as a very talented firm with offices in the Equitable Building on 120 Broadway. About a dozen lawyers at the time, and others were associated. That was not a tiny firm in that day. In late 1926, Sylvia Beach, his Paris publisher, and Joyce met with Paul M. Hahn, one of the principal attorneys for Chadbourne, who was visiting Paris. Hahn had received his LL.B. from Columbia University in 1917, and the next year joined Chadbourne. In Paris, Beach and Joyce rehearsed the tale of Roth's atrocities and piratical activities, and Joyce was persuaded to seek $500,000 in damages, an enormous sum in 1926, which is something like $6.5 million in buying power, at least of 2012 when I checked. Joyce paid a retainer of $150, the only amount he ever did pay them, And in late January 1927, Hahn sailed for New York with instructions to file that lawsuit when he hit ground. Once legal trouble really began to brew, Roth, through the noted civil liberties lawyer Arthur Garfield Hayes, whose name probably means something to a number of you, he was involved with the helping with the Scopes monkey trial, and other, Sacco and Vanzetti helped with their appeal. He was a noted civil liberties lawyer who also was had his own firm. Through Hayes, now that everything was beginning to kick up, Roth offered Joyce $1,000 to make it go away. Actually, as $1,000 for permission to continue with Ulysses in his magazine, which by 1927, 26 actually, he was serially reproducing in Two Worlds Monthly. And that $1,000 would have consisted of a $100 check plus 4 promissory notes of $100 each and a final promissory note of $500, payable, said Hayes, depending upon Mr. Roth's future prospects. And he enclosed a pre-drafted release, incidentally, that Joyce was supposed to sign, that said this was actually an offer made before Roth began publishing Joyce. The proposal, let's say, was not calculated to appeal to the Paris-based author. Conditional payments out of future profits were reminiscent of 19th century trade courtesy. They might have seemed reasonable to Hayes, who was persuaded that Ulysses was in the American public domain. But Joyce had little interest in a new serialization, really. The book is already out as a book, and it's percolating into the United States that way. Why a new serialization? And really, Joyce could neither depend on nor verify these payments, these future promised payments on these notes. More than that, though, by the time this offer was made, Joyce was preparing a big lawsuit, and this international protest signed by many authors, 160 or more international authors and major figures, had been circulated, or was about to be circulated. That was much, much, much better for, frankly, publicity purposes than getting a dubious $1,000 from Samuel Roth and allowing that to go forward. Joyce never even replied to Hayes. Meanwhile, the Chadbourne attorneys were cranking it up. In March 1927, they served a summons and complaint on Roth. The complaint was remarkably plain and simple, consisting of 6 brief paragraphs talking about simply identifying Roth's company, stating that at sundry times Roth and his magazines had knowingly made use of the name of the plaintiff, as he was referred to in the complaint, meaning Joyce, of course, without the plaintiff's consent, and that this was being done for advertising and commercial purposes. The prayer for relief sought an injunction and that $500,000 in actual damage and such exemplary or punitive damages as might be appropriate. It was what the complaint did not say that was most striking. No reference at all to James Joyce's famed authorship, no mention of the book Ulysses, no allusion to Roth's unauthorized reprinting of the novel. Piracy, textual mutilation, non-payment, those outrages that Beach and Joyce were trumpeting in the press, nowhere to be found. Instead, the complaint focused entirely on Joyce's name. His attorneys had chosen to base the lawsuit on a state statute, Section 51 of the New York Civil Rights Law, which forbade commercial misappropriation of certain indicia of personality. Notably, the name, portrait, or picture of a person. And this constituted what was thought of at the time as a statutory right of privacy. The New York legislature had enacted this in 1903 after a woman, Abigail Roberson, sued, claiming that she had been humiliated by the use of her, unwanted use of her image on advertising for Franklin Mills flour. And the court rejected, at least the High Court in New York, the Court of Appeals, rejected her claim, saying that this so-called right of privacy has not yet as found an abiding place in our jurisprudence. The legislature acted a year later by enacting the statute that gave a right of privacy. So Joyce's bare-bones complaint characterized him as an ordinary individual whose privacy had been invaded. And the Chadbourne attorneys were careful. They pleaded no more than they needed to. Very bare-bones, I think, so as not to, we'll talk in a moment why, not to invoke a quick dismissal or arm Roth with affirmative defenses that could have been raised. The attorneys no doubt felt that a claim based directly on copyright and brought in a federal court would have been difficult to sustain. No U.S. copyright existed, as we know, in the Paris edition of Ulysses, and even the Little Review serialization, there were question marks about the copyright protection of that work. Joyce's attorneys also had reason to worry that if they asked the court for equitable relief in the form of an injunction, that the issue of Ulysses' status as a scandalous book might come back to haunt them, and the court might refuse to grant equitable relief to a plaintiff who has unclean hands, as the legal term goes. Joyce's ink-stained hands were pretty well known by 1927 when the suit was launched, and I think the concern would have been that relief would have been denied, at least on that basis. Much of the actual management of the case, the day-to-day work on the case, was conducted by a young Chadbourne associate by the name of Eugene Frederick Roth. Roth, R-O-T-H. He could have been no more than about 22 or 23 when he was assigned to the case, fresh from studying law here at Columbia. He was unrelated to Samuel Roth and could scarcely have been more different. Samuel was a volatile, risk-taking Luftmensch, and I get that great word from Jay Gertzman, Luftmensch, hovering on the margins of respectability, yearning to be accepted but as an author and publisher, but willing, when necessary, to cast aside strict probity. He frequently wrote, Samuel did, about Jewish experience, and you'll see some of that in these cases, and drew upon his memories of the Eastern European shtetl from which he had emigrated to America as a boy. In contrast, Eugene Roth, who had come to America from Hungary at the age of 9, coveted the white shoe world of law firms and corporate affluence, and later served as, he married the wealthy daughter of one of the owners of the Phillips Van Heusen Shirt Corporation, later served on their board as their counsel. According to his daughter, who incidentally is the feminist author Anne Royfe, Eugene Roth was a handsome, driven climber who married for money, practiced law for power and status, and erased all sentimental ties to the old world. 4 days after Samuel Roth was served with a complaint, his attorney, Nathan Padgug, entered his appearance in the case. Nathan Mordechai Padgug was of a different cut from the Chadbourne attorneys. He was a Lower East Side attorney who mostly worked solo or with a few associates. At the age of 10, as I learned from his son still living, he had come to the United States from Minsk and settled with his family on a chicken farm in New Jersey. At 16, he ran away to New York to escape his tyrannical father, and he obtained a high school diploma and then went on to New York University, earning his LLB at NYU in 1915, graduating in the same class as Charles Reznikoff, who of course later famously became a poet. Padgug was an interesting figure, and much of my research into this whole dimension of Roth dug up for me these very interesting and colorful characters who populate the legal world at the time in New York. Well, Samuel Roth had a knack for making himself scarce when necessary. Joyce's attorneys had to engage 2 different agencies to attempt to serve him papers fixing the date for his pretrial examination, or as we would now say, deposition. Process server finally caught up with him in May of 1927 at 72nd Street and Broadway, not far from the luxurious Ansonia Hotel, where, flushed with the early success of his magazine ventures, Roth had installed his family in an 8-room apartment. That was a real luxury digs in those days. Pre-trial examination without a court order. Law students and lawyers are very familiar with that nowadays, but it was much less common in 1927. It had only been authorized by statute in New York a few years before. The idea of just being able to go and take your opponent's deposition without applying to the court for a special order. One of Joyce's attorneys, Harold Callan, began the deposition of Roth by asking him if any of his magazines had carried an advertisement referring to the serialization of Joyce's Ulysses. See, he wanted to, if he wanted to get Roth using Joyce's name for advertising, he wanted to get evidence of that. He didn't get much of it, actually, in quite the way he wanted. But Roth refused to answer any of these types of questions on advice of counsel, so he was folding his arms and not speaking. Unable to extract testimony, Joyce's attorneys walked him over to the Supreme Court, or the New York County Courthouse down there, and they applied to a Supreme Court justice named Phoenix Ingram for an order requiring him to answer their questions. After listening to extemporized arguments, the patrician judge Phoenix Ingram ordered Roth to answer the questions on pain of being held in contempt of court. So they go back, and Callan resumes and begins asking about Roth's profits. And Roth says, I can think of much surer ways of making a profit than publishing my magazines. If he ever did realize a profit, he said he would use the windfall in furthering the artistic ends of my magazine. And I think these things are partly true, what he's saying. This altruistic pose was not wholly insincere on his part at all. Callan then confronted Roth with the complaint's central allegation that he had been exploiting Joyce's name for commercial purposes, and Roth denied this. He said, I'm only using his name to show who's the author of this book. It's really kind of I'm respecting his moral rights, right to be designated as the author of the book. One thing that, Roth then stressed that the work was not copyrighted in this country. He pointed this out very strongly during the deposition, and no doubt he was probably coached by Padgug. He was putting on record certain facts that could support a complete defense under the civil rights law that he had been sued under, which was an express exception for, that is, there was no liability of this sort if you were simply using an author's name in connection with his or her book, which had previously been released to the public. What's wrong, after all, with naming the author of a book? Now, are libraries going to be liable under this statute? During the grilling, Padgug, the lawyer for Roth, objected frequently on all kinds of grounds that would nowadays not be appropriate, relevance and so forth, calling it a fishing expedition. And he tried to keep the focus strictly on this name issue and off of the Ulysses issue. Whenever Ulysses came up, he would object and say, that's not within the issues. That's not within the issues. You haven't sued on anything regarding Ulysses. You've only sued about his name, the use of his name. Now they turned to monetary damages because he was asking for, they were asking for so many, and Roth had incautiously boasted in the second of the Ulysses installments magazine. He had boasted that 50,000 copies, he said, of the first number had sold, and that Ulysses was part of the reason. Not a good thing to put on record for lawyers, but he did it, he said it. It was probably an exaggeration of some sort, but nevertheless, a lot of copies, I'm sure, of that first one did sell. And then they also were interested in Roth's own profits, because the idea was we could measure our client's damages in part from how many dollars you made out of this. But there's questionable causation when you think about it, because after all, if Ulysses enjoyed no or questionable copyright in the States, how could Roth's serialization of a public domain novel have harmed Joyce in any way? More fundamentally, if an unexpurgated Ulysses could not legally be published and circulated in the United States or imported, how could postulated lost profits on a banned novel be a meaningful measure of anything? Always ready to flaunt his credentials as a martyr to modernism, Roth answered about the circulation, saying, it has decreased very appreciably since the announcement of an article by Mr. Joyce. He says his readers were finding the work brutal. His word, interesting word, brutal. At one point, Eugene Roth, very young lawyer, wanting to get in on the action, he wasn't conducting the deposition. He was simply sort of jumping in every once in a while. And at one point, he says, "Well, do you think your novel is interesting to the people?" And Roth replied, "Interesting to me." The kind of studied Wildean subjectivism, that is the only standard, he said, on which I judge anything. Callan tried to steer the discussion back to Ulysses, at which point Padgug served them with a flourish with a stay and an order to show cause, which essentially was a motion which he should have filed much earlier, asking the court, in essence, to stop the deposition and to impound all the testimony already given over several hours. Well, this was litigated up to, there was an appeal taken, and that's a story, but did manage to put, Padgug was effective in putting that case on ice for many months before it resumed. Now, Joyce's own testimony was critical, but he had informed his lawyers, I can't make it to the United States, either before or during trial. So what they did is they applied, his attorneys did, to the court for a commission to have the deposition taken in Paris by written interrogatories, a very elaborate process where you had to get an order from the judge and a commission, and the commission would then be sent with seals and ribbons and so forth to the consul general in Paris, and then that would be unsealed, and the consul general would have a stenographer, and then he would administer the questions and so forth. And all that was done. Joyce's deposition was taken. He claimed to his lawyer's questions, answer to his lawyer's questions, that he had never given permission to Mr. Roth to publish anything, which was not strictly true. And at least at one occasion in 1926, Roth had sent advance payment for reprinting, did you hear me say it? Advance payment for reprinting certain extracts from Work in Progress, Joyce's pre-Finnegan's Wake, and had made an offer at Sylvia Beach's invitation for the right to be the exclusive publisher of future extracts. But Joyce was in no mood to clutter his deposition with extenuating details. Roth was a villain and must remain so. The questioning went on, and finally Joyce was asked about that $500,000 in damages that he was claiming, and now he's being asked by Roth's attorneys through these written interrogatories delivered by the consul general. And he says, well, how do you get that? And he says, well, the various Paris printings of Ulysses had so far brought him royalties of $50,000. Think of that, $50,000 in mid-20s he was making on that book, $50,000 in Paris, and he expected his earnings in France to rise eventually to $75,000. And here's a quote from his deposition. I calculate that the sales of the book in the U.S., published at a minimum price of $10 a copy, and with a royalty to me of 15 or 20%, with an English reading public of such a huge size, would have brought me at least 6 or 7 times as much as I've made in France, namely $500,000. Of course, Joyce's arithmetic was optimistic. He assumed that at least 250,000 copies of Ulysses would sell for $10 apiece in the United States, with $2 entering his pocket as royalties. In fact, it later took Random House, again, the files are here, 5 years and 10 printings of Ulysses priced at $3.50 per copy before the first 50,000 copies reached the American public. Joyce was also double counting because many copies of the Paris Ulysses had actually been purchased by or for Americans and were getting into the country surreptitiously and supposedly wrapped in ladies' underwear and all kinds of strategies for sneaking it in. The litigation dragged on for months, rather inconclusively, when suddenly in November of 1928, Joyce received a cable from the Chadbourne firm, settling case, defendant in jail. When the cable arrived, Samuel Roth had already served several weeks in the workhouse on New York's Welfare Island. His troubles with the criminal courts had kept pace with his setbacks in civil litigation. In March of 27, he had been served with a summons to appear in Jefferson Market Court to defend himself against the charge of publishing lewd and indecent magazine matter. The complaint had been brought by the Clean Books Committee of the Federation of Hungarian Jews in America. And it took special aim at the serialization of Ulysses. Padgug, who represented Roth, made the case go away somehow. We don't know exactly how. But not before Roth had announced a Two Worlds Defense Fund to carry the fight, as he put it, to the oppressors of the living spirit of beauty, and wondered publicly whether the Clean Books Committee was really the work of those astute friends of Mr. James Joyce, who since the appearance of my magazine have pursued a policy of threatening me through the newspapers and the mails with an interesting variety of unpleasant extinctions. Again, Roth was charged in January of 28 with mailing obscene circulars for something that you will find out here in the cases: Richard Burton's translation of The Perfumed Garden, an erotic classic by Sheikh Nefzawi. And after pleading guilty in federal court, he was given, Roth was a suspended sentence of 6 months in prison with a probation of 2 years. And scarcely 4 months into this probation, he was arrested again at the book auction, a business in his wife Pauline's name, for possessing obscene books and pictures, and something that was instigated by John S. Sumner of the New York Society for the Suppression of Vice. And those charges were heard by the Court of Special Sessions in New York, and he was convicted and sentenced to 3 months on Welfare Island. In prison, and the letters are rather touching that are between him and his wife and his children, he produced a steady stream of correspondence, arranging for visits from his wife, chatting with his young children, seeking legal assistance from Padgug, requesting books and magazines, and even recording his delight when one of his keepers in prison mistook his large volume of Lord Byron for a Bible. Roth remained on Welfare Island until January of 1929. Joyce's lawsuit, a faint murmur in the background of his carceral routine. The attorneys for Roth and Joyce had been discussing settlement now, actually, for some months. And finally, the Chadbourne firm produced a draft of a consent decree injunction, that is, an injunction that is agreed to by the parties and entered by the court. And on December 19th, Padgug obtained Roth's signature in prison on that stipulation of settlement. And a week later, the New York Supreme Court entered the consent decree, which was very vast in scope, by the way. It barred Roth from using Joyce's name in connection with any magazine or other publication by Roth and any work by Joyce, including Ulysses. This was actually more tangible and broader relief than Joyce's skeletal complaint had prayed for. And it effectively deprived Roth of the ability to associate Joyce's name with the public domain Ulysses or any work by Joyce, something that the law otherwise permitted him to do. In essence, this negotiated injunction was a stint upon the American public domain, a shrinking of the cultural commons. The Chadbourne lawyers had performed an impressive feat in doing this. By agreeing to the consent decree, though, Joyce was losing his dream of a great precedent, legal precedent that would help authors like him throughout Europe, where the U.S. would finally give relief to this situation. And Joyce really he always kind of wanted that injunction to be more than it was. It was never published. It's not a published case. He can't cite it as authority. It never has been cited for anything. And he later claimed, actually in a very famous one of his few public speeches, he claimed that the little injunction marked a dawning judicial solicitude for the inherent natural rights of authorship. But what Joyce was describing was the European view of authors' moral rights, not the American. After all, far from reflecting moral rights perspectives, the U.S. copyright law of this period allowed authors' rights to be lost forever by simple technical blunders such as omitting a copyright notice from the page of a published book, or failing to renew a copyright after its first term, or failing to print it in the United States. American law, though it would later come to recognize creators' moral rights in limited ways, has never embraced the comprehensive vision of natural authorial entitlements that Joyce really wanted to read into his little injunction. There's an undeniable pathos in Joyce's dream of residual or incipient natural rights for foreign authors in the U.S. He was helpless before the American copyright laws, Straitjacketed by the scandalous reputation of his masterpiece, he had been unable to comply with a rigid statute, and he found no reputable publisher to issue an unexpurgated Ulysses in time. So a disreputable publisher had found him, expurgated his book, and used his growing celebrity to build a magazine. Roth had exploited a famous name and novel, just as the Chadbourne attorneys contended, but his position was not without a certain pathos of its own. He genuinely loved Joyce's gift and had always wanted to be the American impresario of Ulysses. The public domain was as inescapable for him as it was for Joyce. With unprotected riches lying before him and an intransigent author in Paris, Roth could not turn back. Constituted as he was, he had no choice but to publish and be damned. When he received Roth's little offer of $1,000 for that serialization of Ulysses, Joyce had found himself at a crossroads in copyright traditions. Had he accepted the money, the transaction would have linked him to the tradition of trade courtesy with its private payments for public goods and its myriad little clearings of compromise within the wilderness of the American public domain. Joyce chose not to parley with the juggernaut commons, but rather to find a way around it, consciously reacting against the void of legal incertitude. His lawyers decided not to try to enforce a defunct or doubtful copyright in Ulysses, or even to assert the abstract moral rights of aggrieved authorship. Instead, Joyce sued to protect the one thing of his that undeniably had value in jazzy, prudish, bibulous, prohibition America, his controversial name. Rejecting the path of courtesy, Joyce authorized his lawyers to hang that $500,000 tag on his name. What we glimpse in Joyce versus Roth is a right of publicity that is breaking from the husk of privacy rights. A de facto claim of economic harm emerging from lawyerly rhetoric about injured feelings. Joyce was not the only noted figure in this period to try this approach. In 1922, Douglas Fairbanks had used Section 51 of the Civil Rights Law as a vehicle for suing a movie company that had re-edited his motion pictures in ways he found objectionable. Again, a privacy law being used really to redress a more of a copyright type issue. But increasingly, celebrities were just saying, I have an economic value, right, and a property in my name. Charlie Chapman launched litigation of this type. Later in the century, a proliferation of lawsuits sought redress for the exploitation of names, likenesses, or voices of celebrated persons: Bela Lugosi, Groucho Marx, Cher, Elvis Presley, Clint Eastwood, Johnny Carson, and on and on. James Joyce was a precursor of these outraged personalities. Like them, he had sought judicial approval for propertizing his public image. Gazing into the abyss of the American public domain, Joyce's attorneys in 1927 skillfully worked around the copyright problem by basing the action not on Joyce's book but on his name, his signifying persona, the secondary meaning and reputational goodwill that James Joyce, like Blue Valley butter, had acquired in the years since he had come to the attention of the American public. Samuel Roth was a faithful product of the public domain, and in a sense, he was only an occasion for all this legal ingenuity. Yet the litigation took a human toll. Together with the international protest, Joyce's lawsuit did as much as anything else to demolish Roth's ambitions as a serious publisher and to ruin his bid for tenancy in the increasingly crowded house of modernism. Thank you.
Fantastic. Thank you. Carla, you want to come on up? Should we have questions?
You can do it from there, though.
Well, you may. Questions?
I'd be happy to.
Absolutely. I see your hand first.
Yes. Isn't right of publicity more of a trademark issue?
It has trademark aspects to it, certainly, because the idea is that one's name has come to mean something more than one's name. Just as a trademark is a word or a color or a logo that has come to mean more than simply that word. And yes, it has that dimension, and that's actually what I'm kind of suggesting here. In fact, there's been Jonathan Goldman in the audience here has written a fascinating book called "Modernism is the Culture of Celebrity." I got that. Is the literature of celebrity, in which he and he's more and more now doing research on further research on the whole branding of modernism, the trademarking of authorial celebrity.
The reason I ask is because trademark laws are considered more serious and the property is more valuable than just copyrights.
It can be the case, sure, absolutely. Yeah.
But where was trademark law in the 1920s?
Well, it wasn't available to Joyce's lawyers, but I think when you look at the litigation, and the files are, I dug them up in the court archives here in New York, there are elements of trademark thinking in that case, but there was no ability actually to sue for a trademark infringement. Trademark was already there, and there was trademark litigation, not certainly as much as today in the 20s, but it would not have been a reachable theory in this case, I think.
Yeah, and trademark for one's personal name was then, is today, a difficult right to assert all by itself.
But you're absolutely right that publicity rights give a kind of trademarky flavor to the use of name. Of course, with a deceased person, in my state, Oklahoma, you not only have a statute for living persons, the use of their names in a way that misappropriates them, but you also have what they call deceased personalities rights. But you don't get a deceased personality publicity right unless you died with a certain dollar value that could be demonstrated associated with your name at that time. So it can't develop after.
Well, that's the way the law used to be in California, but they've changed it.
Yeah.
Right. But there's still a question of residence, too. California's had some litigation.
Well, I represented Betty Page at one point.
Uh-huh.
And the people who took over her representation, she lived in California, and of course, by then the law had been changed because of the W.C. Fields case.
Right. Right.
Yeah.
Good. Good.
Excellent,
Other questions? I see a hand all the way at the back. Yes, please.
Joyce was a man who took umbrage, great dollops of it, at great speed,
Yes.
facility.
Yes.
How much umbrage did Roth take?
Oh well, I think I can say that he was a man of that flashed very quickly when he felt that he was being dissed, and I think you see it. For example, certainly Jay can speak to this. I think a lot. I think you see it in the reaction to both the rather reasonable defections of both Pound and Eliot. I mean, he turned publicly against them in a very aggressive way. I think he could. I think it was very volatile in that way in my research of him.
Please. It's a pleasant sound.
You mentioned in passing that the serialization and the little review of Ulysses didn't qualify for copyright. Could you elaborate on that?
Yeah, I could. It's not. There's no open and shut on this. The law of the period is very complex. Anybody who, as Kenny has studied, is a student of that. The law under the 1909 Act, the previous Copyright Act, knows that the twists and turns and the arcane rules and the possibilities of losing a copyright for this or that reason. Copyrights in this period under that law were thought of as being indivisible. That is to say, you could not take a copyright and hand out an exclusive right to publication and an exclusive right to adaptation, an exclusive right to movie rights, as you can easily now. It was thought that either, when you tried to do that, you either gave away the entire copyright or you only gave a non-exclusive license. Now, magazines, as you know, very typically state copyright the name of the magazine or the magazine owner. In the case of the Little Review, they all said copyright Margaret Anderson. the question then would be, in order for that copyright notice to be a valid notice vis-a-vis Ulysses, Margaret Anderson, under considerable legal precedent of the period, would have had to be an owner of the copyright in Ulysses. Because she was not, pretty clearly, Joyce had not transferred the entire copyright to her and was unable to transfer exclusive North American rights, it's possible that it was a faulty notice, reciting the wrong copyright owner vis-a-vis Ulysses, which would have meant, and this kind of case came up, there's a famous Dr. Seuss case of the period where this happened, simply lost rights as a result of that. So that could have been, that copy, and we know that this is more than just my, after-the-fact fantasizing. The Joyce's attorneys were indeed concerned about that issue. Now, there are other complexities. There was a whole trust theory of magazine copyright ownership that might have helped in this case, but it was very iffy as to that.
And as you emphasize in the book, getting toward the end of the book, the law today couldn't be more different. Instant automatic copyright protection worldwide. You don't even need a notice. And for at least the foreign copyrights from mid-century, where the notice may have been omitted or was wrong, the law instantly made up for that and swept all those works back under copyright. So the law today is a radical break from what it was at that time.
A radical break, and now copyrights are almost infinitely divisible. I mean, we could take a copyright right now, yes, and we could share out exclusive pieces of it to everybody in this room, and there'd be nothing wrong with that. Then you couldn't do it because they were indivisible.
Going back to the injunction, was there no monetary aspect to that?
No, he got not a penny, and he actually said rather pathetically to his lawyers, couldn't I at least get whatever is the equivalent of the English farthing? Couldn't I get a farthing for it? At least I would be able to claim damages, and that never happened. It was only the injunction. Had he taken that $1,000 or the $100 or whatever you would have gotten up front, he would have actually gotten some money out of this, but he never took it. He turned up his nose to that.
How much did the lawyers on either side?
Oh well, I'll tell you what. I wish I had time to give you the little story. I'll give you the 30-second version. Joyce didn't pay his lawyers. He paid there was a Paris Chadbourne office, an office in Paris, and he did pay a little bit to that lawyer, but never all that was owed to him. And that lawyer eventually, this is not known, it's not known in the any Joyce biography. That lawyer eventually filed a lawsuit against Joyce for essentially unpaid funds. Never collected because Joyce and family scooted to Zurich, with the coming of the occupation. But I will say that here in New York, these lawyers here were owed over $2,000, which Joyce never paid a penny of. And he said that he had reasons. He said after all, I thought the injunction was good, but after all, it's just a worthless piece of paper. He said, I'm not paying it, although it didn't stop him from making these grandiose claims for it at other times. And so, and $2,000, this is something like, $30,000, $40,000 today. So that's at least a good piece of lawyer work. And they still know it at Chadbourne. They know this. There was in 1999 there was a Chadbourne newsletter. They have, law firms have their newsletters. And I had a friend who was working there at the time. He said, "Do you know this?" And he sent me this copy. It was a little article about how Joyce never paid, and that even if he had paid, we should just frame the check, because it was about celebrity,
Statute of limitations on that. Please follow up on that.
Do you think this story would be different if John Quinn had stayed alive?
Yes, I think Quinn would have been more aggressive. I do think Quinn would have been more aggressive towards Roth. He was very effective when he wanted to be. Frank Delaney in the back and I were talking about this earlier today. How he was a very impressive lawyer, a very determined lawyer, and I think he would have squeezed something more out of that situation just because of his devotion to Joyce as well.
But hasn't Quinn been severely criticized for mishandling the Jefferson Market lawsuit?
Oh well, There have been criticisms. You know, he was in a very difficult position at this time. You know, this is 1920. This is 1920, 21. There is a obscenity. Good obscenity case law was undeveloped at that time. I mean, you were 10 plus years still away from the Ulysses type decision, you know, there really wasn't much he could do. I think he did about as much as he could with what he said were a very difficult three judges on that panel.
Please.
So the Roth serialization was an expurgated version of the Shakespeare Ulysses?
Well, Jay Gertzman has written very, I think, informatively about this. He points out, I think very interestingly, that the Roth serialization was actually less of a Bowdlerization than certainly installments in Little Review. Certain installments, especially the ones that Pound had pruned. But you know, I mean, Joyce wasn't thinking really about the Little Review anymore. He was thinking of it vis-a-vis the 22, which was available now. And if not perfect, it was unexpurgated. And, you know, there was some expurgation that Roth undertook, and you know, he dropped a whole page of the 22 at one point. You'll just see a whole gap which begins at the beginning of one page of the 22, and it just dropped out a whole. I mean, there were, you know, it was not a perfect thing by any means.
Yes, please.
I feel like this might be common knowledge, but it's eluding my memory. Didn't the Roth version then become the one that Random House used to put out?
Yes.
Yeah. Okay.
Yeah, they thought they got their hands on a bona fide Paris edition, and it actually turned out to be Roth's counterfeit. So they set it up from that. They set up the 33 from that with some of the howlers and added some of their own for spice.
But it's from the book, the printed book he issued.
Yes.
Not
Right.
the serialization.
Not the serialization. Yeah, the book. The Roth also did a rather underground type book version of it as well.
But how could that have happened since Sir was dealing, I guess, with Castor, who was Joyce's son-in-law, and
well, you see, Roth
get something directly from Joyce?
Yeah, well, see, Roth's piracies were getting into Paris, and I believe what happened was they probably Paul Léon. I'm just speculating, and maybe Jay knows for sure, but I'm assuming that Paul Léon or somebody got his hands on a Roth piracy and shipped it over to the United States as if it were authentic.
It was hard at first to get the customs agents to care about Ulysses anymore by 1933. And I think that Random House and the lawyers had to ask customs, so please intercept this next book we send.
Yeah.
Because we want to make a trial case out of it.
Yeah.
And it happened to be one of those Roth full-length Ulysses that he had set up by some printers in New York City. I can see why it would happen, because a lot of booksellers and even policemen would get their hands on confiscated literature and not return it.
Yeah.
They could sell it.
You know, Joyce called the Roth piracy when he learned that it was circulating as a Roth-inspired book. Joyce was referring to the French law of contrefaçon, which is a sort of actually counterfeiting of luxury goods, like an expensive perfume, a knockoff would be called a contrefaçon. So he's thinking of Ulysses as a kind of luxury book. After all, it's a very, very expensive book for the time. It's a luxury item.
They're hard to tell apart. The only difference is the thickness of the paper, if I recall seeing them side by side. I mean, it has the blue cover and everything. So
I think so, yeah.
If you didn't have another copy from comparison, it would be pretty easy to be taken.
Or if you're somebody with very bad eyesight.
It's also a very highly prized artifact in private erotic concerns. One of the first subscribers to Ulysses was the well-known collector of pornography and erotica, Winston Churchill. Paid £100 for his copy.
Goodness. That's a lot of
That's a lot of money.
Maybe just one last.
Yeah, one last question. Thanks.
Bob, do you know where the plates come from? The Random House plates that they use on the printing book?
Well, they set the book. that they set the book. I'm pretty sure because there's a you see the Cerf saying, you know, just as soon as the Woolsey decision is handed down, he said the typesetters are going at it, which is really rather bold. I mean, out here you can see an ad for the Random House Ulysses that was issued in January of '34, barely a few weeks really since the decision, where he says we already have the last word now on this. Of course, it was on appeal, and it could have been reversed. I mean, there was no guarantee that would not have been reversed before the year was out. After all, it was a 2-to-1 decision as it was, with the two hands on one side and Martin Manton, the now infamous Second Circuit judge, on the other side. It's infamous for taking bribes on the bench. Later. I wonder who bribed him to dissent. I think it was his own conscience. Anyway, yeah. So, but I think it was set up for him.
And Carla is telling us that our time may be up. So
yeah, thank you very much. That was a fantastic talk.
Thank you.
Thank you.
Thank you.